Hello and welcome to our webinar on ISDA documentation, focusing on the ISDA Bank Custodian Collateral Transfer Agreement and Security Agreement. This is part of a series of webinars looking at recently published ISDA documentation that enable parties to comply with regulatory requirements related to initial margin. My name is Graham Bryant, Legal Counsel in ISDA's London office, and I will be joined today by Doug Donoghue, a partner in Linklater's Derivatives and Structured Products Group in New York. I'll start by giving an overview of the Bank Custodian Document Initiative, and then I'll hand over to Doug to provide a bit more detail on the content of those documents. As many listeners will be aware, during the course of 2018, ISDA created a working group open to all of its members with a view to developing documentation for use in connection with regulatory initial margin requirements. The credit support deed for initial margin, governed by English law, and the equivalent New York law-governed credit support annex for initial margin were published in October 2018. ISDA have made available a number of separate webinars addressing the terms of these documents in more detail. Please refer to the ISDA website for more information. During working group discussions throughout 2018 leading to the publication of those documents, market participants provided feedback that it would be useful for ISDA to publish separate documents that split out the terms relating to the collateral transfer mechanics into one document and the terms relating to the creation and enforcement of the security interest into another. The rationale for this separate document initiative was to mitigate any issues relating to conflicts of law where parties are using custodians located in jurisdictions outside of New York and London. As noted in this slide, the document structure allows parties to align the governing law of the collateral transfer provisions with the governing law of their underlying ISDA master agreement, whilst also allowing parties to match the governing law of the contractual provisions creating the security interest with the law of the location of the relevant security account and posted collateral. The collateral transfer agreement contains largely the same collateral transfer provisions as the 2018 credit support annex and credit support deed. The document structure has been designed to create a simple architecture in which the collateral provisions are governed by one document and the security provisions can be tailored to suit the specific requirements of each trading relationship, in particular allowing parties to post collateral with a custodian outside of New York or England. The security agreement is intended to create a valid security interest as a matter of the law of the jurisdiction in question. ISDA has already published forms of security agreement governed by English and New York law and intends to publish further such forms of security agreement for other jurisdictions in due course. I'll hand over to Doug now to run through the documents in a bit more detail.
Thanks very much, Graham. So as Graham said, the purpose of publishing this bank custodian CTA and the related security agreements was really to mitigate any risk that may arise from having custodians in jurisdictions other than New York or London, where you would have the pledge contained in your ISDA collateral documentation be governed by one law, and then the assets be governed by the law of another jurisdiction. And the reason I wanted to underline that before we even get into the slide is the purpose of this was not to really change any of the substance of the ISDA published Reg IM, CSA, or CSD, but to just move the provisions into a format that would allow them to be more flexible for both phases 4 and 5 as we continue to see more and more custodians come into the Reg IM space. So on the slide in front of you, what you have are a few key differences actually between the bank custodian documents and the existing Reg IM, CSA, and CSDs published by ISDA. The first thing that you'll notice, and I should actually back up a little, a lot of the differences that you see on this slide are caused by the fact that the bank custodian documentation, much like the ISDA CSD, is a document that is related to the ISDA Master Agreement, but does not form part of the ISDA Master Agreement. So the New York law CSA, as we all know, forms part of the ISDA Master Agreement. The English law CSD is a document related to, but does not form part of, the ISDA Master Agreement, and the same is true for the bank custodian documents. Now that's important, and wanted to point that out here, because that leads to some differences as between, in particular, the CSA and the bank custodian documents. Principally, Those differences are the fact that you need to provide a governing law and a jurisdiction provision in the bank custodian documents, and that's obviously not required in the New York Law CSA because the New York Law CSA relies on the governing law and jurisdiction provisions that are provided for in the ISDA Master Agreement itself. So what we did here is we took that idea that we would be relying on, as we do in the CSA, the governing law and jurisdiction provisions that the parties have agreed in the ISDA Master Agreement to be applicable to a Reg IM collateral document, and we have hardwired that as the initial choice, or as the presumption, I should say, in the bank custodian documents. And what that means is that both your governing law provision and your jurisdiction provision in your CTA will be, in the first instance, based on your governing law and jurisdiction provisions in your ISDA Master Agreement. Now, you can always customize those in paragraph 13 of the CTA, where you would make your specific changes as between you and your counterparty. But in the initial instance, as I said, the presumption is that you will rely on the governing law and jurisdiction provisions that you've agreed in your ISDA Master Agreement. Also in paragraph 13, there are some of the CTA, there are some jurisdiction-specific provisions. A couple examples are up in front of you on the screen. The Contract Act provision, which is required under English law, and the jury waiver provision, which is not required under New York law, but is very common to be seen in a New York law document. The other jurisdiction-specific provision that is hardwired into paragraph 13 are the JGB provisions. And interestingly, you'll see that the JGB provisions that ISDA has published a couple of years ago have actually been split amongst the CTA and the SA. Now that we've broken the CSA and CSTs into two documents, the CTA and the SA, we needed to also break those JGB provisions, and you'll see some of those provisions in the collateral transfer agreement, and some of those provisions in the relevant security agreement. One of the reasons that the bank custodian docs from a jurisdiction and governing law perspective have been set up this way is that the idea is that they should be able to be used alongside the English, New York, French, or Irish law master agreements. And in fact, ISDA has already published some additional French law riders to be used in the event that you are using these bank custodian documents with a French law ISDA. Now, on the security agreement side, obviously we don't rely on the ISDA Master Agreement for purposes of governing law, because the whole idea behind the security agreement is that the governing law should be flexible there, in that it doesn't need to be the same as the governing law of the ISDA Master Agreement, because you want to be able to match the governing law of the security agreement, or the document where the security pledge exists, with the governing law of your custodial agreement. If we move to the next slide, what we're really highlighting here is, again, I really do want to underline this theme. We did not reinvent any of the substance of the IM CSA or the IM CSD published by ISDA. Instead, we just changed the form to make it more flexible for the eventual entry of more custodians into the Reg IM space in different jurisdictions. And what we've tried to do on the slide in front of you is really break down a 2018 IM CSA into its paragraphs and show you where those paragraphs are covered in both the collateral transfer agreement and the security agreement. And I'll just highlight a few. So the collateral transfer agreement, as we all know, is really intended to cover off the mechanics of the collateral flows. And as you'll see from the check marks, the CTA covers paragraph 3, paragraph 4, paragraph 5, paragraph 6, and paragraph 7. So it basically covers how you calculate your collateral, the timing of transfers, and events of default, all of the mechanics around collateral transfers. And then if we look at the column on the right-hand side, the security agreement, really the two that I want to point out are, it covers paragraph 2 from the 2018 IM documents, paragraph 2 being the security interest. So the pledge is a local law pledge, because again, the security agreement, the idea is the governing law of the security agreement will match the governing law of your collateral documentation with your custodian. And then paragraph 8, so the rights and remedies provisions. And again, we wanted to match the governing law of those provisions with the governing law of your collateral documentation with your custodian, because if you're ever enforcing a security interest pledged under under local law, you'll want your rights and remedies to also be under that, to be governed by that local law. So I'll say it one last time. The idea here was not to reinvent any of the terms that we spent a lot of time on working through for the 2018 IM, CSA, and CSD. It was really just to put it into a different format so that it was easier to use for market participants who wanted to use custodians outside of London and New York.
So that brings us to the end of this presentation focused on the ISDA Bank Custodian document. So I'd like to thank Doug Donoghue for joining us today and running through those slides. Thank you for listening. If you have any further questions regarding this presentation or ISDA's initial margin documentation generally, please feel free to contact us at ISDALegal@isda.org. Thank you.